My name is Dan Binstock. I am a partner with Garrison and Sisson, an attorney search firm based in Washington, D.C. And I am very excited to have today Tina Solis, who is a partner at Nixon Peabody. Tina, I have known you for a number of years now. I've seen you speak at NALS conferences, and you've always been a hit. People love hearing you because you're able to translate what's kind of murky into very actionable, tangible takeaways. And I know that you're one of the very few go-to people that attorneys in the lateral market go to when they're dealing with really complex issues. So I'm super excited to have you here today. And thank you for being here.
Well, Dan, thanks so much for having me. It's always a pleasure to be with you. And we've worked so well together over the years that we've known one another. So thank you so much. And happy to answer any questions that you have, because you know this is a sweet spot for me.
Wonderful. So we're going to try to make this as we've got 10 questions, and we're going to go through them, and we're going to have fun with this as much as we can have fun with ethics. So tell me a little bit about sort of how do you help partners with the lateral process? What is the role that you play?
Certainly, I help in a wide variety of ways for individual attorneys or groups that are moving from one firm to another. The first is in a counseling role in terms of the do's and don'ts in connection with the process, and in primarily adhering to their fiduciary obligations that they have, not only to the current firm, but to their clients as well. So that's sort of the first role or function that I can play. In addition, I have also dealt with helping attorneys get return of capital from their current firms. That's another issue that often arises in connection with the departure process. And then a third way that I can assist is in helping, assessing, and analyzing and comparing the various offers that a departing attorney or group of attorneys may have after they've completed the interviewing process. So there's a multitude of ways that I can counsel and assist, and it just depends on the level of involvement that my client would like.
Wonderful. So let's talk a little bit about a question that I think a lot of people don't really understand, which is what law or authority really controls a lateral partner move. I know I see ABA ethics opinions. I see state bar associations providing opinions on what you can and can't do. And then there's state law, there's federal law. How does all of this stuff work together in terms of what authority controls?
That's an excellent question, Dan, because you're right. There are a lot of different places that you need to look. And of course, I'm going to give the favorite lawyer answer that no one likes. And the answer is, it depends on what law applies based on the issue that we're dealing with. But there are a few places you have to look. So first of all, the ABA and its model rules are a go-to place. And you are correct. There are ethics opinions that the ABA issues on a fairly regular basis. And as you know from one of my prior talks at NALS, on December 4th, 2019, the ABA issued a very comprehensive opinion in connection with fiduciary obligations and the departure process. So the ABA is one of the first places to look. But you also have to keep in mind that each state has its own set of ethical rules and professional liability rules. And so one of the things that I look at when a client retains me is, where is that attorney licensed, and where is she or he currently sitting and practicing? Because we not only have to take guidance from the ABA and their ethical opinions, but we also have to look at the specific case law within the state, which sometimes, depending on the market you're in, there can be a fair number of opinions in that state. In other states, this is not such a robust issue, and so you may not have as much guidance within the state. In addition, when you're dealing with attorney departure issues, one of the key contracts that you must look at is the applicable partnership agreement, because that too really contains the rules within which you're playing. And so you must not only look at the partnership agreement, but what law governs that partnership agreement. I'll use, for example, because I'm sitting in New York today in our New York office, you may have a lawyer in New York, but he or she may be subject to a partnership agreement that has governing law in the state of Pennsylvania or the state of California. And so that comes into play. And then last of all is, as you talk about, state law and federal law, depending on what applies and what particular issue we're dealing with. So it's a very complicated and complex analysis that needs to be done. And unfortunately, I say it depends because I can't give you a clear answer without knowing the specifics. But those are some of the places that you need to look when you are trying to figure out how best to handle this.
Thank you. And does state law trump what what is sort of the controlling authority if you have state bar association that may be perhaps at odds with a state law opinion? Is there any way to know what controls, or is it depends?
Again, unfortunately, it depends, because are we really looking at a state contractual issue based on the partnership agreement? Or are we truly looking at what the attorney can or cannot do in connection with the departure process? In that situation, you're probably going to take a state ethics opinion over the partnership language. But again, it all depends.
Yep. Okay, great. Thank you. That's super helpful. Another question that I have is, when we think about the competing interests, there's always what you're supposed to do based on what, the ABA opinions say, the state bar, what we just talked about before, versus what we actually see some partners actually doing in terms of what's in their best self-interest to preserve the portability of their clients. And sometimes these things really are at odds because, there's a tension between following the guidance and doing what is, in the partner's own self-interest. And I see that come up all the time. What do you see from your end as sort of the competing interests among the partners when trying to thread these needles at particular points in the process?
Certainly. And, you've hit it spot on. During the departure process, there are a lot of interests that are competing. And again, it's situationally specific, but what I can tell you in terms of the hierarchy is that an individual's duty to the client trumps the attorney's duty to his or her current firm and partners. I mean, that's one of the things that is clear throughout the case law and the ethical opinions. As attorneys and fiduciaries to our clients, the client's interests always trump all else. But again, as you mentioned, Dan, there's also, the competing interest of, well, wait a minute, I have a right if I want to switch firms and go work at another firm, but how do I make sure that I maximize my chances that my clients are going to leave with me and that, there's going to be minimum disruption to the matters that I'm handling for them? And so because it is oftentimes a difficult situation to navigate, that's why I think it's so important to have someone counseling you along the way and to explain to you whose interests trump in what specific circumstances. So there are competing interests there, but as you well know, because we've done this together many times before, you can navigate those waters and you can get to the other side safely while meeting all your clients' interests, also maximizing your own self-interest. So there are ways to do it, but again, it's very situationally specific. And so that's why I think it's always good to have the best advisors on your side when you're going through this process.
Absolutely. And one thing that I remember, I had a story with a partner candidate who was convinced that he could not do something, and I had him speak to you, and I thought I'm pretty sure I'm pretty sure he can do this, but I just wanted independent counsel. And then he spoke with you, and he realized that he could do it, and that was a big relief because you were able to give him sort of the practical experience and the practical advice on that, which it makes a big difference. At what point in the lateral process do ethical issues, now we're going to really sort of dig into them, but at what point do they really start to become relevant and triggered? When should someone start to become aware?
Very good question. And I appreciate you bringing it up, Dan, because one of the things that I find is easier for me, the sooner a client gets me involved in this process, the better it is, because we have a much longer runway to plan the process, and timing and sequencing is very important. So to directly answer your question, ethical issues start much earlier in the process than I think most people realize. So typically, where it arises is when a partner is filling out lateral partner questionnaires from firms that they may be interested in joining, because during that process, you have to make the decision, what information do I include? How much can I include? And you have to, again, walk that fine line between providing the firms that you're looking at with information that's relevant to your practice, so metrics can be discerned, yet at the same time, maintaining the confidentiality of the firm information from your current firm. So typically that's when it arises, but I'm going to give you an example that may happen, not often, but I've seen it time to time, and it's much earlier in the process. So for example, you may be an individual attorney and you're thinking, now may be a good time in my career for a move. The market's very robust, and maybe a bigger platform is the way I want to go. And I had this situation happen just 2 weeks ago. An attorney's thinking about moving, and he or she gets a call from a client and says, attorney, I want you to handle this project for me. It's a deal, and XYZ firm is on the other side. And XYZ firm just happens to be one of those firms that the attorney is interested in exploring. What happens at that point in time? And in that situation, the attorney did the right thing. They called me and they said, Tina, what do I need to do? Can I move forward, or do I need to hit the pause button? And in that particular situation, and I won't divulge any further facts, but in that particular situation, we decided it was best to hit the pause button. So you never know when a situation, and thankfully, this person was just starting to think about those possibilities. So it was early on in the process, but you just never know when an ethical situation may arise. And so, Dan, once someone has spoken to you about a move, I strongly encourage them to also reach out to, someone with ethical expertise, because you never know when you may hit a bump in the road. So the long-winded answer, sorry about that, is they can arise very early on.
Yes. So during the process, is there any sort of burden in terms of the partner supposed to disclose less at the beginning, but can disclose more during the, because by the time you're through the LPQ, they know a lot about your practice. And we'll talk about that in a little while in terms of really digging down. But during the interview process, what is appropriate when talking about sort of your existing clients, your existing, rates with clients? If you've got special rates, if you've got a client that you've negotiated something that's, significantly below what the market value is, what are some of those things that partners should be aware of during the earlier process, but before they get to the LPQ?
Certainly. So I think when you are doing the initial interview, and each firm has its own system. But if you do an initial interview, it's important to keep client information at very high level. So in other words, there are ethics opinions that say for purposes of conflicts, an attorney is entitled to disclose just the name of the client for conflicts purposes when he or she is looking for other employment. But when you're in the interviewing process, it's important to talk about information that, resides in your own head that you can say off the top of your head. I do think from a full disclosure standpoint, right? Because you have an obligation to be truthful and accurate with regard to the firms that you are interviewing with. It's important to talk about, where your general rate structure is, what that range is. And to your point, Dan, if there is a client for which you have a negotiated rate, I would talk about that at a very high level. And you have to, dependent on the circumstances, advise, the firm at that time what the client's name is if you think it's appropriate, or if you don't think it's appropriate yet, and that's in the process, just talk about it at a high level. But it really is a balancing act of maintaining the confidentiality of the current firm's information, yet also being truthful and maintaining disclosure with the firms that you are speaking with. And so again, it's a balancing act, and with your guidance and with an ethics advisor, I think it's a line that attorneys walk, and they walk it all the time, but it's always helpful to have that guidance behind them.
Great. Yeah, that's always from my end is advising on the firm wants very specific information, and to thread that needle without looking like you're being cagey or withholding because you might think it doesn't appear to be positive, but when in all actuality, you're trying to just honor the ethical obligations, and that's where it all gets very murky. In terms of the interview process, another question is, I will have partners all the time say, you know what, I was talking to this new firm. They said that they could use, 1 or 2 associates. I'm going to go talk to these associates to see if this is something. And I was, whoa, stop. Can you give us some detail on who partners are able to speak to at their own current firm about a possible move and the different levels of fiduciary duties as it pertains to the different tiers of lawyer or staff at the same time?
Another great question. And it is an issue that inevitably, Dan, comes up every single time. So generally, and I say this generally because there are state-specific rules, but generally, if you are what's considered an income partner or an equity partner, if you are a partner, you are entitled and allowed to talk to your other partners about a move. And so you are not violating your ethical or fiduciary obligations to speak to other partners. However, in today's world, as we know, there are multiple titles within a firm. We now have counsel positions, there are associate positions, and the general rule, and again, generally, I draw the line between if you're a partner, you're allowed to speak to your other partners. If you are thinking about a move and there may be associates or counsel position or staff, you are not permitted generally to speak to those individuals prior to departing. And if an attorney were to do so, he or she would be violating one of their fiduciary obligations. And so again, these are part of the do's and don'ts that we talk about during the departure process, because in today's world and in my experience, and I know Dan, in your experience, oftentimes groups move together, they want to move together, they have a cohesive team that they've been with for a long time. And it's very important to enable a group to make that happen, but you have to do it in the right way without violating any of your obligations.
Okay. And this obligation, and I'm sure people watching this are probably thinking about talking to clients, and we'll get to that in a little while. But does this obligation to not speak to if anybody other than a partner, so that includes counsel, associates, anybody else, paralegals, legal assistants, secretaries, any kind of assistant, it's everybody. At what point are they able to talk to them? And I know we'll talk a little bit more in the notice point, but if we could just kind of mention that.
Yes. So generally, the bright line rule is you cannot, to use a legal term, solicit any of those people or speak to any of those people about joining the new firm until after you have left your current firm and joined the new firm. That's sort of the bright line rule. Now, here's what
bright line rule.
You're right. Here's what makes this area of the law so murky. We all know there's the bright line rule, and then we also know there's the reality and the practicality of how this plays out. And so you have touched on one of my favorite topics because it always comes up. The minute notice is given, we don't operate in a silo. The minute notice is given in today's work from home, you immediately get calls because your associates, your staff members, your team, they're concerned if they hear that the partner they're working with is moving. And so what I always advise my clients to say is, listen, I appreciate the call. It's great hearing from you. You have to understand, I'm a partner with fiduciary obligations at my current firm. And so you have to understand that I'm going to abide by those obligations, but I'm happy to speak to you when I am able to do so at the new firm.
And I love you, and nothing could make me happier than imagining a future together.
Exactly. That is exactly right. And again, you have to find a way to adhere to your obligations, but also understand the practicalities. You don't stop talking to your teammates the minute you make your announcement. And oftentimes in these situations, what I will say to clients is, listen, if it's a situation where you're leaving and, it's you and several of your partners and it's a group, and the current firm recognizes that the group may be leaving, right up front, you may want to say to your current firm, listen, I'm going to respect the obligations set forth in the partnership agreement, and I'm certainly going to abide by my ethical obligations. But if it would be okay with you, may I talk to Associate A, Associate B, Associate C? And, the key here to doing this in an amicable way is try to be transparent with your current firm. This is what I would like to do. And oftentimes the firm will say, yes, that's fine. We don't have a problem, and if they do have a problem, they're going to let you know it. So I'm a big believer in transparency. I think where things sometimes go off the rails, and this is why I tell clients, be upfront, let the firm know what you want to do, because, we work in a small legal profession, and I'm a big believer. You try to do this with transparency, and you try to do it so no bridges get burned. You want it to be amicable.
Yeah, that's great advice, Tina. And so many times on my end, there's almost I think people get scared. They don't know how the firm is going to react. And we can talk about this more when we get to real sort of the notice thing, but just emphasizing the importance of really kind of taking the high road is a smart business decision in so many ways. And when people start thinking about what's going to be best for my practice in the next 30 days, rather than over the next 12 months, they really fall into, it's almost like lower brain thinking, fight or flight thinking takes over, and they start making poor judgment because they get so panicked that, oh my gosh, if all this business doesn't come with me right during the first 30 days, as I promised on the LPQ, I'm going to be like that partner at my current firm who came over and promised this, and they didn't have that business. And we've all been talking behind their back on how frustrated we are that they're in a 2-year guarantee. And so it's a lot of people really get themselves unnecessarily panicked. And that's part of the role that we play, is to try to kind of keep an eye on the long game.
That's exactly right. And, let's be very upfront. Attorneys have very stressful jobs. And then you add the additional stress of thinking about a move, and it's 2 full-time jobs.
Right.
And so you're right, Dan. Our job is to talk to them, walk them through this, and say, listen, you have to keep your eye on the long game here. And if you take the high road, and I tell clients when they first retain me, I counsel very conservatively. I don't believe in walking too close to that line. It's not comfortable for me. And trust me, it won't be comfortable for you. You want to take the high road. You want to do the right thing. And in the end, it's going to work out much better for you. You have to trust me on this one. And so I think you're right, but I can't tell you the number of times where someone has said to me, after a 5-minute call, they call and they're very concerned about issue X. And I say, oh, that's an easy one. This is exactly how we handle it. And 2 minutes later, they say, oh my goodness, that makes me feel so much better about this. And now we're not only doing it the right way, but we've relieved their concern and their stress. So that's a big part of how I view my job in connection with this part of my practice.
Yes, wonderful. So let's talk a little bit about the LPQ and due diligence. And that this is really kind of where we dig down a little bit. So regarding client information, you provided before sort of general information, but a lot of LPQs nowadays say, list your client, list your billings, your collections, your realization rate, your standard rate, your effective rate for the past 3 years for every one of your clients. And they all have very similar questionnaires. So is it okay to share that? And if it's not okay, according to the rules, is it the risk reward? Because I cannot see a partner coming back and saying, I'm sorry, I can't share this because this goes beyond my ethical and duties. And, that's going to probably, sink the deal. So what do you advise? First of all, is it okay to answer that information? And if it's not technically okay in some jurisdictions, what is sort of the real world advice on this?
Certainly. So let's start out first, and I'm going to get to client and billing rates and all that in a moment. But let's start out first with compensation, because there are some states that have enacted laws that state you don't have to provide your current level of compensation if you don't want to. And there are some recent developments there. And so what I would say
Can I interrupt you on that one, Tina?
Yeah.
Does that apply to owners or employees? Because my understanding was that it applied to employees, but it's unclear as to whether that applies to income partners or hybrid income partners. So before we go into that, if you could provide a little bit more clarity, not that.
No,
yeah.
You're absolutely right. And your assessment is consistent with my current understanding. And again, it's balancing what the statutes say versus real world advice. And so I have had situations in which clients did not feel comfortable providing that information. I will tell you personally, I think it makes it more difficult to get a deal done if that information is not provided. But ultimately, for owners or partners, the decision is up to them. But I raise it because, again, it's another hurdle or an item to consider in the analysis. But Now let's jump more directly into, information regarding billing rates, clients, realization rates that the LPQs always ask for.
Right.
And again, you have to balance your obligations with the practicalities and providing information. So if you want to make a move, you can make that happen. And I think the biggest rule or the biggest takeaway that I can say to people listening to this is do not attach reports from your current firm. Please, please, please do not do that.
What do you mean by
certainly
the report? What is a report?
Certainly. So oftentimes in today's world, when you work for a firm, you get monthly reports of here's the amount of hours worked on for this matter. Here's all of the team members and the hours they generated for this particular client. Here's the overall revenue that you generated on a monthly basis, a quarterly basis, an annual basis. Everyone gets their metrics before they do their self-evaluations. Please do not take those reports from your current firm and do not attach them to your LPQs. That would be a violation of your fiduciary obligation. So please do not do that. Having said that, if you have a practice and you've been doing this as long as I've been doing this, you have a very good sense of what your rates are, who your team members are, if you have a special rate for someone. As I stated a few minutes ago, you are entitled to include clients, the name of clients for conflict purposes. The ethical opinions allow that. And so do your homework. I know the LPQs can be lengthy, but don't take the easy way out. If you take the easy way out, chances are you're violating your fiduciary obligations. Sit down, do the homework yourself, synthesize it in your brain, and then complete the LPQ to the best of your ability. And trust me, the firms that you're speaking with, they don't want you to violate your obligations either. I will tell you something that I'm starting to see, and Dan, I'm certain that you're starting to see this. There are representations and warranties in these offer letters from the new firms that I didn't see 5 years ago. So be mindful of that if you're exploring new opportunities. There's a right way to do this in which you can navigate these waters and get to the other side. Just be smart and think carefully about it.
The advice I give to people is anything that has your firm's name on it, your firm's logo on it, any kind of stamp on it, like a document number, just copy and paste it and put it into a document and take all of that other stuff out. Even that's better than giving the document itself, because it's the same information, but you got to make sure you're not giving any more than what is asked for and what is needed. When it's got people's names on it, timekeepers, stay away.
That's right. You have to be very careful in the information that you share. And, I say this, you want to complete it to the extent that you can move to the next step in the process. But I'm also a big believer in you don't want to give too much upfront in the process. And, maybe one of the things that we should jump to next is client referrals, because I have a pretty strong opinion about where that belongs in the process. So I leave it up to you, Dan.
Yes, please.
One thing that we always see in today's day and age is the request for client referrals. And I think that's something that attorneys who are contemplating a move need to be very mindful of. I'm not saying don't provide that information, but there's a right time and place to provide that information. And it's not when you're looking at 5 or 6 different firms at the outset. I always say when you initially complete LPQ to say those will be provided at the appropriate time. And then once you get through the process, you've worked with Dan, you're getting towards the end, and it's down to 1, 2, 3 offers being made, and you're seriously doing your final analysis and comparison, then I have no problem disclosing that. But I just think that is a piece of information that belongs in the latter part of the process when you're getting much closer to making a final decision than right up front.
So I have a follow-up on that. So in terms of disclosing versus having the new firm call them,
Correct.
tell
So,
me when things start to shift on that analysis.
yes. So it's one thing to say in the LPQ process, I represent ABC company, I represent XYZ corporation. Completely fine to do and allowed under the ethics opinion. So conflicts can be run. And for someone like me who's a litigator, easy to do because, those case captions are publicly filed information anyway. However, what I mean and the distinction for client referrals later on in the process is identifying who at ABC company these firms that you're speaking with can be contacted and disclosing Mr. or Miss GC at company ABC is something that should occur much later in the process.
Okay, so you're saying even identifying the people, even if they're not going to call them, the identification of who your contact in reference is should not be shared until later.
I think that's right, because unfortunately, I've run into some situations in which the firms that are considering the candidate may have pulled that trigger too early in the process, and that's not beneficial for anyone.
Right.
So I find that if the candidate holds that information until the end, you're minimizing the risk that a telephone call is made a bit too early in the process.
Right. What I advise my candidates to do is always, if they list a name saying, please do not call without even if the document says, please be assured we will not call any of your contacts without your explicit permission, still to reiterate
Yes.
that, just to be, I'm a little healthily OCD, which I think, you can never be too careful.
You can never be too careful, especially in this process, because as we know, it is so highly confidential.
Exactly. So it's okay so is it okay for a firm to call a reference? Let's say someone's down to the end with a firm and they say, we just like to kind of check. We're not going to ask the questions we're not allowed to ask in terms of will you send business, which I know firms are not allowed to ask, but if they just want to check this person out a little bit, when are they permitted to do that before the partner notifies his or her partners?
So again, I counsel very conservatively, but I also understand that, the firms want to be able to verify certain information about the candidate. And so in my perfect world, it occurs as close in time to the attorney providing their notice of withdrawal as possible. And what does that mean, Dan? Again, I'm going to give the lawyer answer that no one likes. It depends on each situation, but I do prefer that to be as late in the process as possible. Just to protect not only the individual candidate, but also to protect the clients and to protect the new firm as well, because no one wants to be accused of tortiously interfering with anything.
Yes, absolutely. Thank you. Great answer. And in terms of accepting an offer, why is accepting an offer such an important piece of the process?
It is a very important piece of the process. And, it signals to the new firm, I'm on board, I'm ready to move forward with this. And from an ethical standpoint, and we also have the legal standpoint as well, but from an ethical standpoint, I never want any of my clients, quote unquote, working for two firms at the same time. And so You want to sign that offer indicating you are going to make the move. And then, of course, you want to provide notice to your current firm as closely in time after you sign that offer. So you're not working for two firms at the same time. And also, the situation is, I talked about timing and sequencing and how important that all is in this process to do it the right way. Once the acceptance of the offer comes in, it triggers all of the other events, including notice, after you've provided notice to the firm, who you can speak to and when, and all of that. And so, yes, accepting the offer is very, very important. And again, that should be done after you've done the analysis and comparison of all the offers you have. I typically don't recommend that my clients sign an offer if they're still waiting on two others. I think it's much better in the process to do your apples to apples comparison before you make a decision to sign an offer. And again, we're doing this in a way that meets all your fiduciary obligations. And it's a small legal community that you work in. You never know what 10 years can bring down the road, what 20 years can bring. And you wouldn't want to jump the gun and sign an offer, and then another one comes in and you change your mind. So I always advise my clients, try to get them all in as close in time as possible, analyze them, and then make your decision.
Yeah, absolutely. I've got a tricky question for you, but I know you can handle it. Let's say it's October. You know where I'm going with this.
I know exactly where you're going.
It's October. Partner decides they want to move to X firm. They don't want to move before February because their final distribution comes out between October and February. They've decided they want to move to that new firm. What should they say to the new firm in a way that, that signals their strong intention, but also keeps them from running afoul of any potential paper trail that could exist and come back and bite them?
Yes. So in that particular situation, purely hypothetical, here's what I would suggest. And understand when I answer this generally, I'm not talking about a specific jurisdiction's law or the specifics of a partnership agreement. I'm answering this very generally because obviously knowing what law governs and where that attorney is could impact this decision. So generally, all those caveats.
Very high level hypotheticals.
Yes. Very high level hypothetical. What I would say to that attorney is, please do not sign the offer letter at this time. That's not in your best interest or the new firm's best interest, despite what they might think. And what I would do is I would send a verbal signal, a strong verbal signal to the firm that you want to join, that, you have every strong intention of joining in February, and that is your hope. But I certainly would not sign an offer in that situation. It is a very difficult position for that individual if they were to do so. And I'm just a big believer in not creating any headaches that you don't have to have at that time.
Perfect. Perfect. So anything else regarding acceptance? I'd like to turn to giving notice, because I know that's but is there anything I missed to ask about the acceptance process?
Yeah, no, I think we've covered it at a very high level, Dan. And as you know, once that acceptance does get signed, then it triggers the notice to the current firm. And then that's really when I start having fun, because again, timing and sequencing at that point is critical.
So tell us about the notice process and what is the role that you play during the notice process, what are some of the mistakes you see when giving notice, and sort of the best practices and the worst practices to stay away from?
Certainly. So in giving notice, again, it should be as close in time to signing that offer letter as possible, because you never want to be questioned as the departing attorney whose interests were you serving during that period. So you
Riding
want
two
that to
horses.
go. Exactly. So notice is very important, because there are typically notice requirements in the partnership agreement that must be met. And there are also typically notice periods in partnership agreements, in which most firms will try to enforce those notice periods. Now, the ethics opinion that came out in December of 2019 from the ABA basically said notice periods can no longer be a specific amount of time. Oftentimes the partnership agreements say 30 days, 60 days, 90 days. What the new ABA opinion said is, listen, the amount of notice that a partner should have to give is consistent with notifying the clients in the proper way and taking all the steps to transition those client matters to determine whether those client matters are either going with the departing attorney to the new firm or staying at the current firm, or perhaps, this is rare, but it sometimes happens, going to a new third firm. And once the effective transition has been made and the clients have made their decision with regard to the files, you really should not be holding an attorney past that process. And so, these artificial 30, 60, 90 days are not really something that we can rely on anymore. And so that was a very important ABA opinion that came out that offers guidance on this issue. So what I would tell the departing attorney from a best practices standpoint is make it as close in time to signing your acceptance. Consider what client matters you have and impending deadlines coming up, knowing that there is going to be a period of time that you have to remain at your current firm. And I get clients that say to me all the time, Tina, there's no perfect time to move. I have deadlines every day. And I appreciate that. But look for the big deadlines. I mean, you probably don't want to be giving notice if you have a matter that's going to trial in the next 2 weeks. You probably don't want to be giving notice if you have a big deal that is closing 3 days after you give notice. Just be mindful of those things. Be mindful that you may have to stay at the current firm for a while. And then most importantly, and I'll get to clients and what you can say to the clients in a minute, but most importantly, know how to properly give notice and make sure that it's comporting with the partnership requirements that you are subject to. And now let's talk a little bit about what you can say to clients and when, because the end all be all rule in this part of the practice and area of law is there is no pre-resignation solicitation of clients. Any departing attorney who solicits clients before they have provided notice to the firm are committing a breach of their fiduciary obligation to the firm. And so that is the preeminent takeaway. No pre-resignation solicitation. There are ways in which you can provide your notice that is consistent with ABA guidance. But generally, you need to take your current firm's guidance on when you can speak to the clients and what you can say to them.
Can I ask one quick question?
Absolutely.
I know we talked about this earlier in connection with references.
Yes.
In the real world, partner has a big client they've been representing for 20 years. All of a sudden, client's going to get a call from potential new firm saying, I'm just calling to talk to you about so-and-so. The partner's going to need to give the client a heads up that they're going to be getting a reference call, which in all intents and purposes is going to be not a solicitation, but a notification to the client that I might be moving. And if they're smart, they're going to do more than just drop this bomb on a client and leave it at that. So not that you need to give an answer to this, but kind of just acknowledging that it may be a little bit of a murky area there in terms of navigating that.
Yes, it's a very murky area in terms of dealing with the client referrals. And then the other murky area, and again, it's difficult for me to talk in generalities about these two particular.
Yeah, I'm not gonna push you for specific stuff, because I know it's so murky, and often what the law says and what people do in the real world, there's often so many different variations.
That's right. But the client referral is a situation in which I would recommend anyone who's moving had guidance on. And the same thing is true for providing notice to the clients once you have given notice to your firm that you're leaving. There are tried and true ways of doing that with joint client notification letters, and there are ways that can be handled. And again, that's something that I routinely assist my clients with. And so there's very right ways to do this, and there are wrong ways to do this. And I will tell you, for those of you who may be listening to this, don't feel as though, oh my goodness, I went to law school. I passed the bar. I've been practicing for many, many years. I can't believe I don't know any of this stuff. This is a very particular area of the law, in certain jurisdictions, not particularly well developed. And so again, I would just urge you to get proper guidance on this, because these are tricky situations. And, these are areas in which firms are paying particular attention to, where 10, 15 years ago, maybe they were not monitoring it as closely as they are today.
Right. Great. In closing, what are some other comments, or is there anything else that I've missed that you think is just kind of pressing important, or do you want to give some sort of closing thoughts on this? You are amazing. You've got so much great practical knowledge on this, and I can see why people really like working with you. So thank you.
Well, thanks, Dan. Here's what I would just say in closing, because we covered a lot of ground. But I would say, for those of you who are thinking about a move, don't be scared to engage in exploring those options that are out there, because you can successfully make a move. And yes, there may be some murky areas and some tricky things, but with the proper guidance, it's done all the time, and it can be done successfully. And so I certainly would not want anyone to shy away from this, because there are people out there like Dan and myself who can help you with this and make the move easier.
Wonderful. Well, thank you, Tina. You are wonderful. And this was always a pleasure speaking with you. And I'm so grateful for the time that you spend and all this information you shared. And I know that the people watching this will appreciate it as well. So thank you. I really appreciate it. This is wonderful.
Well, Dan, thanks so much for having me. And I look forward to hopefully being able to see you in person soon again.
Yes, absolutely. Bye-bye.
All right. Bye-bye.